listening to the Hearse Chaser podcast show. Here's your host, Stephen McClellan.
All right, welcome back to the Hearse Chaser podcast show, and this is a topic that comes up all the time on phone calls and in-person meetings, and so we're going to title this Estate Showdown, Wills versus Trust Explained. So we had many different titles that we came up with. That's the one we like the best, Showdown, because it often is a showdown when it comes to explaining the difference between wills and trust. So I'm going to start with wills because that's what everybody knows. Wills, if you have a will and that will is old, it will likely be folded nicely in like a brochure type length and width, and it will have blue on it. I don't know what happened, 20, 30 years ago, but that was the most common estate planning binder, that they would just staple the blue on it, and that would, protect it from fires and theft and secure it, having an extra blue on there. It's not so common today to see that extra piece of paper put on top of it. But if your estate plan still has that blue, it's probably been a while since the estate plan was actually done. So primary purpose of a will is best explained in this way. It is instructions that trump the intestate statutes of your state. So intestate is when you don't have a will. So what a common misconception people have is, I don't have a will. That's true, but the state that you live in has some will for you. It may not be what you want at all, but we have some language that will instruct the living heirs about how assets go. And it's really funny, that default is a strange thing. And I remember when I learned about intestate statutes, it was the fall after I got married in the summer. And of course, very excited about getting married in June, and we were just completely in love, and I'm walking in, and we're talking about decedent estates, and the professor asks, whoever's been married for less than 3 years, raise your hand. I raised my hand because it'd been like less than 3 months. And she said, I don't know if you know this, but if you've been married for less than 3 years in the state of Arkansas, not everything would go to your spouse. And I was like, well, who would the other people be? And they said, well, if your parents are alive, then it would go to them. And so I immediately was terrified, thinking that Arkansas doesn't think my love is enough for my wife of 2-3 months. And so we immediately did wills stating that if I die, I wanted everything to go to her. Under no circumstances was anything to go to my parents. And that's one important reason to have a will, to make sure that assets go where they're supposed to, okay? What people often think is that you write a will, you write it up, and then you, when you die, you give this, there's a reading of a will. Everyone is around a table in a lawyer's office, and they read a will, and I've never really done that. There's never been this unveiling of what is in the estate planning documents. We don't do it that way. The will is filed at the courthouse. Okay, so we file a death certificate and the will at the courthouse and open up probate. And depending on a number of different factors, it may be a short probate, it may be a long probate. And if you've read stories that probate can be over a year or over 2 years or 4 or 5 years, it's true. It certainly can. There's a number of factors for the length of probate, and some of those are within the attorney's control. Some of them are not within the attorney's control. But a will is just instructions to a judge saying, hey, judge, this is where I want my assets to go. So that judge is going to validate and say whether or not that will is good. So in one of my earlier podcasts, I talked about the fear of the failures that come with do-it-yourself. And that judge is going to scrutinize that will based on Arkansas or whatever state you're living in. So that's how a will works. Now, what's interesting is a lot of people think, well, that will is going to affect all of my assets. It's going to affect my bank accounts, my life insurance. No, it doesn't affect all those things. A will is going to affect what's in your estate. So your bank accounts, if they have beneficiaries or life insurance, those or where those assets go, what does the will affect? Well, the will is going to affect things that don't have beneficiaries on it. A lot of times that is a home, that is some financial account that wasn't properly set up, any number of things. Okay, so that's a will. That's when the will comes into place. My general opinion is I think wills are fine when you have young people, okay? Young people that want to make sure that they have guardians for their kids. That's where that language is put. So if we want to make sure that you want to make sure a sibling or some other person is guardian, that's where that information is. So the question is, well, what is a trust? Well, a trust is also a written instrument, and the most common trust is a revocable trust that you set up prior to your death, and you set up your assets. That's the key. Set up the assets to go into the trust. Now, you might wonder which one's easier. Well, a will is much, much easier to set up. You just do a will, and in the amount of time I've spoken, 6 minutes or so, I could have probably drafted a will, and it could have been signed. But there's a lot more work involved in a will, dealing with courts and probate attorneys, and it can be kind of difficult. Whereas a trust does have some work, but there's less work on the back end. So it's sort of a trade-off. Most clients who talk to us say we want to set things up to make things simple for our kids. And, well, that's not a will, right? A will is just instructions for probate, and it's a lot of time and energy. There are a number of studies out there that try to track how much time a personal representative has related to probate. Personal representative is like the executor, and you know, it's a lot of hours, okay? And there's still things to do whether you have a trust or you don't have a trust, but the idea for most of our clients is with a trust, the assets go into the trust, it avoids probate, and you name one person in charge. So let's just take a bank account, for example. Someone sets up a bank account, high yield savings account, and it has $100,000 in it, and you die. Well, if the account was just in my name when I die and I have no beneficiary on that account, then Arkansas law will say where that asset goes. You've been married for more than 3 years, and you have kids, it doesn't all go to my wife. Okay, if it's just in my name, it doesn't all go to my wife. It actually gets split between my wife and kids. And you might think that's a terrible outcome. Well, the law is what the law is, and there's a number of situations where there are blended families, and maybe you want some things to go to your wife, some to your new kids. So the law kind of splits it in the middle. It might be fair to say that if it were a blended family in that situation, the $100,000 in our state, the majority would actually go to the kids, not my wife. Okay, and how much my wife gets depends how old she is in that calculation. So scenario number one, $100,000 in my name, there is no will, it is going to be divided among my wife and kids. If I have a will that says everything goes to my wife, then it all goes to my wife. If I have a will that says everything goes to my kids, I can't quite do that, okay? Because our state doesn't allow you to totally disinherit your wife, okay, or your spouse. That's a protection that my wife can take against a will. So yeah, I might think, I'm giving everything to my kids, but the spouse has some rights that trump that, okay? Now, I could also put a beneficiary on the account. If it's my kids, it all goes to my kids. Goes to my wife, it all goes to my wife. That trumps the statutory language related to dower rights. Dower rights is what we're talking about there, with the spousal rights taking against a will. But for most folks that we have set up a trust, the money, the $100,000, goes into a trust like a bucket, okay? And what's nice about that bucket is I put one person in charge of that bucket to collect the money and distribute that money based on my wishes. Now, here's one of the big benefits. One, it's private. It doesn't get filed anywhere. And it is there's protections in a trust that you don't have when it comes to a will. For example, if your assets go through the probate court, the number one concern a judge is going to have is, are there any creditors? That's kind of what probate's goal is to make sure creditors are satisfied and then pay the beneficiary. So if there are more debts than there are assets, as you can calculate, nothing goes to the beneficiaries if there's nothing left, okay?
Thank you for tuning in to the Hearse Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearse Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearse Chaser podcast show.
So that's how that process works. But if I dump it into a trust, then people can make claims against the trust, but it's a lot harder for them to prevail or say we want funds. We can say, well, that it goes into the trust, and the trust doesn't say pay all debts. Now it might, and you have to be very careful. If you do have a trust, you want to know what the language says about debts. Okay. That can get tricky. That's probably a great podcast of its own if we talk about what does your estate plan actually say, because if it does say pay debts in a situation where the grantors or the trustees set up the trust and they co-sign for a kid, then there's an argument that the co-signed debt gets paid first before it's divided evenly among kids. And that kind of frustrates, I think, what most parents want when they want things evenly, but it kind of depends. So just keep that in mind. But with a trust, I avoid probate, and I avoid probate fees, which are very expensive. So if you look up the probate fees, how much they are, you're going to find ranges from $5,000, maybe $1,000, but $5,000 for a full probate, up to $20,000. Okay. And that number really depends on the complexity and the amount of fighting that goes on in probate. And fighting in probate, some of it is just, why are you fighting? I mean, the law says what the law says. It says divide it 3 ways. We divide it 3 ways. And so I think some of the fighting is related to how long it takes. They don't have a clear expectation of how long probate lasts, or they say, well, there's more assets than there should be, and that's maybe because the other beneficiaries or heirs of that probate don't understand how things work. Some things pass outside of probate, and some don't. So that can be a kind of a surprise to them. So if your family gets along, trusts are fantastic. If your families don't get along, trusts are fantastic too, because you can put one person in charge. And some people say, well, why do I even need the trust? Let's say I have a bank account and I name 2 kids as a beneficiary. Well, here's why. One, typically most banks say if kid 1 dies, everything goes to kid 2. That's typically not what people want, because most people say if kid 1 dies, I want it to go to their descendants. Okay? So when it comes to trust, there's more contingency planning about the what ifs. And with the trust, kid A can go to the bank, collect the money, and divide it 50-50. Because kid 2 is probably busy, has other things going on. So that's a real big benefit of having the trust. Administration. It's just very easy for one person to collect everything. Or a home, for example. This is a big one. If the asset is a home and it goes through the will, then you're going to have to get the court's permission to sell the home. That slows down the process. It adds cost. Some people may say, well, look, I've got a deed on my home that says when I die, the home goes to my kids. Well, the problem with that in my state is if it goes to 3 kids and they're all married, all 3 kids and their spouses have to sign off on the sale of that home. And it only takes one of them to be difficult, and now it's holding up the sale. So it's easier if it's in the trust. Because if I have 3 kids and I know one of them is not going to like the price, or they're going to argue or fuss or fight, my trustee can say, you know what, I'm going to sell the property. And I can do that under the authority of the trust and divide the proceeds. Okay, so that's a real big plus when it comes to trust. If I were, making sure that wishes were consistent. A lot of people ask about the cost, and this comes up a lot. I know my intake team, the people who answer the phone, will get the question, well, how much does something cost? And boy, that's a really tough question because we don't know the extent of your estate planning needs. It's like calling and saying, oh, how much does a car cost? Well, it depends, right? There's all kinds of cars. What is your goal? Are you looking for a minivan? Are you looking for a classic car? Are you looking for a car for a teenager? All these cars have different goals and different price points, and that's sort of the way it is with estate planning. We often try to give a range to folks, but without knowing a little bit more about how much they want us to be involved in their estate planning, it can be very difficult. But generally speaking, wills are inexpensive. They are not going to be that much, but on the back end is probate, so which can cost $9,000 to $15,000. So price and cost are 2 different things. Price is what you pay today. Cost is what the kids pay when you're gone. And for some people, they're very price conscious. They want to make sure they get the lowest price, and they don't really care about what the cost is later on. Other people say, no, I this is a gift to my kids. I want to set up what I can do to make things go smoothly and reduce the cost that they have when we're gone. So generally speaking, price for a trust is more than the price for a will, but the cost is much lower. And that's where the huge savings is when you set up things, you have an ounce of prevention, it's worth more than a pound of cure. And I've often joked over the years that I would love to put probate lawyers out of business. And unfortunately, that's not happening. I've seen the statistics in my state, and it actually points the opposite direction, which there are more probates filed now than there were 10 years ago, over 20%. And I think that's due to a number of reasons. I think some people do their own estate planning, and this wasn't a thing 20 years ago. The idea of doing your own estate plan online is becoming more prevalent. So people think, I have a will, and it avoids probate. And maybe I should just put a billboard out there that says, wills do not avoid probate. and just see how many people call that number and say, I thought a will avoided probate. I don't know, maybe I'll do that, but people, I think, believe that, and I've even had an attorney, believe it or not, question that. They said, well, you're telling me a will goes through probate? And yeah, it does. So I've even had attorneys not understand how that works, and so I can understand the confusion, and I don't think television portrays how things actually play out. And I think that's one of our biggest philosophies when we talk to clients is to say, well, let's start with the end in mind. If that matters to you, how things actually go when you're gone, then we have to have the discussion about, well, what's a will and what is a trust. Which one is right for you is a tough question. it should be noted that when we do trust work, we also do a pour-over will. In case you leave something out of your trust, the pour-over will says, put it into my trust. So it's hard to say. I think everybody needs to start with a will. That's what I did when I first married and knew what the law said, and when we had kids, adding that guardianship language. And would I have a trust today if I didn't have, if I was an attorney? It's hard to say. I'd like to think I would. It's a lot easier being an attorney and drafting a trust. And a lot of times when I look at families, I say, look, I know how trust work, and I know how much simpler it can be. Is there any way that we can make this work? And so the big question is, who's going to do that additional work on a trust? You got to be very clear, whether it's the attorney doing that work or the client doing that work, to make sure it's set up. Otherwise, the trust is simply a expensive will. And I see a lot of that. I see a lot of trust that are basically high-cost wills because it wasn't set up in the right way. So I can't really say, well, it's will versus trust. I feel like it's setting up a trust the right way, making sure it's funded properly, but also thinking about the circumstances. And every family has its own goals, and sometimes wills are a great place to start, and maybe a few years later, you think, yeah, maybe a trust is the right choice. So when it comes to the showdown, it really depends on talking to the family. Most children, I'll tell you this, the last thing I'll say is, most children don't ask how much the estate plan was. They never do. Most children want to know, well, how much does it cost me now? What do I have to do? If it was a trust, they're really happy that they don't have a mess to clean up. If it's a will, a lot of them said, I wish mom or dad would have done something different sooner. So it's not uncommon for a child to say, I'll pay for the estate plan to make sure it's done right because I don't want the headache. I've got a lot going on in my life, and I don't want to have to be dealing with probate lawyers. I don't want to be dealing with court. I don't want to show up to court. And so that's probably the best way to talk about the price point, is to say no child has ever said, well, how much was this? Was this too much? Because good estate planning, it's not a price, it's not a cost. It's really an investment for the future. So thanks for riding along with the Hearse Chaser today. Hope this has helped understand the difference between will and trust. Hopefully it helps as you continue the ride of life, and we thank you for joining us today.
Hey, thanks for listening to the Hearse Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.